four categories, Miller, I have segregated now.
But look at it's a systemic fraud.
Miller, just look at the directions then, Miller. Is this fair?
How do you displace these findings, Mr. Gupta?
Miller, I'm not displacing all those four categories, Miller, I have segregated now.
But look at it's a systemic fraud.
Miller, just look at the directions then, Miller. Is this fair? Look at the directions now.
And ultimately, Mr. Gupta, what happens is this.
Yes.
Today, public jobs are so scarce
Yes.
and so valued
Yes.
that if the faith of the community in public employment goes,
Yes.
then nothing remains. But you have nothing to show that this is the data which I have maintained.
Miller, I'm sorry, Miller, if this data is...
What you have within your system, any traceable record to show that this is the data I have maintained.
Very good.
Yes, Mr. Gupta.
Yes, Miller. Just 2-3 facts, Miller. First of all, Miller, the advertisements are given out, Miller, in 2016 for this batch of recruitment. There are 4 batches, Miller, 4 categories of persons to be appointed. First one, Miller, is class 9 and 10 teachers, assistant teachers of class 9 and 10, for which there is a rule of 2016. Secondly, Miller, for which also there is a separate rule of 2016. Similar rules. Thirdly, Miller, Group C and Group D employees, clerical and Miller subordinate. Most of the appointments, Miller, were completed in 2018.
Which is the fourth category?
Fourth category is Miller C, third category is C, fourth category is D. Group C, Group D, clerical and subordinates. Non-teaching, yes. My learned friend is right, Miller. The third and fourth categories are non-teaching.
Yes.
Now, Miller, the appointments were given on various dates after counselling. Miller, mostly in 2018. And Miller, they started working from 2018. In 21-22, Miller, the writ petitions started coming in. By this time, the panels, validity of the panels had gone.
How long was the validity?
Miller, 1 year. Different dates, Miller, but 1 year with Miller, 6 months extension possible in certain cases, and Miller, in some there is no date, Miller. There is no Miller period mentioned. Now, in 21-22, Miller, these matters were brought in, Miller. There was a series of orders by the learned single judge, some of which came to this honorable court, Miller. And one of those matters, Miller, one batch, by order of 9th of November 2023, was, Miller, remanded, but not to the judge, but, Miller, to a division bench. Now, this did not cover, Miller, the whole batch of matters which were before the High Court. It covered some. This went to the division bench. The division bench has taken this, Lord, stand. This is the judgment, which is before your Lordship today. Now, my Lord, this is the first appeal. The learned single judge did not dispose of the matters. Before that, your Lordship said these matters. It will be disposed of by division bench. So, my Lord, the division bench disposes of this matter for the first time. And this, my Lord, is the first appeal we had. Now, what is the substance, my Lord, of this order? Your Lordship has seen, my Lord. First of all, the issues, if your Lordship sees, and then I'll go to the directions. The issues are at paragraph 118, page 187 PDF. And Millard, on the side, I'll put the answer also, Millard. Now, just see, Millard, does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? This was because this hearing was set up pursuant to a particular order of this Honorable Court, which dealt, Millard, mostly with the OMR sheet problems. And, Millard, the learned Chief Justice was directed by your Lordships to place it before a bench. Now, the learned Chief Justice, Millard, passed an administrative order, and, Millard, it was placed before this division bench. The first contention was that this means that a particular batch is before this court, not a PIL. Right. Yes. Millard, I'm not making too much of an issue with regard to that, because the court said, let us treat it as a PIL. But, Millard, the result is, Millard, that there are many matters still pending before the single judge of this very batch. There are many matters pending before the appellate court, and there are several matters pending in this honorable court. And now, Millard, there is an actual conflict between orders of this honorable court and this judge. Millard, I am only pointing out, Millard, that it is not possible, Millard, for this matter not to be heard of. Notice, Millard, and your Lordship must hear it out, Millard. That's Millard, where I am going now. Now, then, Millard, that was the first one. Answer is yes. Your Lordship sees at 118, whether they have the jurisdiction, answer is yes. I'm just saying, Millard, the judgment says. Second one is, are the writ petitions maintainable at the behest of unsuccessful candidates who have filed the writ petition subsequent to the expiry of the validity period of the panel? Answer is yes, primarily on the basis that we are taking it up as a constitutional court, it's a public interest litigation, so the maintainability will not come in the way. Then, Millard, appointments be made subsequent to the expiry of the validity period of the ballot. Now, my lord, this is not investigated at all. In one particular line, my lord, it is just said casually that it can't. Now, my lord, there is a factual background to it. Sometimes there is a rule backing it. Sometimes there is an executive order backing it. And there is a reason for, my lord, the extension. Because, my lord, for various reasons, my lord, the actual counselling had got delayed. And, my lord, there was COVID also. So, therefore, that is no. The answer is no. 4, my lord, is the certificate dated 19th of September 2022 valid and admissible in evidence? Answer is yes. And I'll give you a lecture.
Gupta, you are paying for the commission, right? You didn't create these supernumerary posts. It's really the state of
supernumerary post is one small aspect of this matter, my lord. Very important, no doubt. The state is concerned with that, my lord. But the real substance of this matter, my lord, is the cancellation of the my lord, appointments. I will come to, my lord, the directions now to show your lordship, my lord, that this kind of a far-reaching order, which affects, my lord, a huge number of people, which is blatantly unfair on the face of it, because people who have actually taught for 6 years are being told that they have to give back money that they have been paid as remuneration.
So we are now arguing the broader aspects of the matter.
No, these are directions. I'm asking for stay. I'm asking for notice and stay. Not.
Now, when did you destroy the OMR sheets? Is there any specific provision or so long?
There is specific provision. There is specific provision. We are supposed, Rule 21 is there. We are supposed to, my lord, ensure that digital copies are maintained. Digital copies were maintained. Of course, my lord, it has been recovered from, my lord, an employee or an ex-employee of the concern which was asked to scan it. Now, regarding that comes, my lord, the fourth my lord, question or issue. That gentleman has given it to the CBI with the certificate. My lord, the court said there should be a certificate under 65B of the Evidence Act. So,
but you gave the scanning work.
Yes.
To that NISA.
Yes, correct.
Right. Now, yes. NISA appoints that data scan tech.
Yes.
Your chairperson says I'm not even aware of the appointment of data scan.
Correct, but this is not an outsourcing. NISA retains full control, my lord, who they are sending to my office to scan it actually, whether it is an employee of NISA or whether he is using some other person.
And you appoint NISA without even a tender.
No, my lord.
Just sort of forward the contract to NISA.
All this, my lord, is the kind of, my lord, overriding statements which are there in the judgment. NISA was appointed by way of a limited tender, in the sense, my lord, that several organizations were asked to quote. And this was found to be the best quote. 4 organizations were asked. Your lordships have said as early as 1986 in Sachidanand Pandey that it is a valid method by which the government may, my lord, farm out work. There can be a limited tender. It's a very specialized job. It did not require a global tender, my lord, according to us. And, my lord, the whole thing is, my lord, that they have come. They took the contract. Who actually went into the office and scanned it, my lord, was their concern. We have no relationship with data scan. So therefore, my lord, ultimately.
Now the OMR sheets have been destroyed. You say that because under Rule 21 they had to be destroyed.
That's right.
But even the mirror images on the scanned sheets are not in the SSC.
That's right, my lord. It was, my lord, being accessed from NICE, NYC. It was being accessed because, my lord, people would come with queries after the date of destruction of OMR sheets. When people came with queries, we took the data from that organization and gave it to them. Now, my lord, just for a moment, my lord, my stand on OMR sheets digital data is, my lord, that we have proceeded on that basis. When the CBI obtained the digital data and, my lord, the court said you should back it up with a certificate under 65B, the commission thereafter proceeded on that digital data. So, my lord, it is true that there are many parties before your lordship who are arguing that 65B has not been satisfied, so therefore this digital data is not to be looked into. But, my lord, the consequence of not looking into it is that then there will be no evidence to show that there is a discrepancy between OMR and what is on the final marks in our server. But we are not saying that. We are saying we have accepted those and we have looked into it, and based on that, my lord, the segregation is to be done. So, my lord, 65B, my lord, is something which will be argued by other persons. The commission, my lord, has so far actually said, all right, very well, we will go by what the CBI has given us. So that is, my lord, issue number 4. My lord, may I show, my lord, the 5th issue? Should the OMR sheets available in the seized hard disks be uploaded in the server of SSC to compare with the final list stored therein? Answer given by court is yes. And, my lord, apart from, my lord, the question as to whether this should be made available to the public in general, 22 lakhs, my lord, or whoever is interested, we have no grievance with, my lord, uploading it and comparing it.
But now, Mr. Gupta, if you go back to now para 335 at PDF 298.
Yes, ma'am.
Where the court sums up what it has found.
Yes.
Let's just read para 335 at page 298. This is where the evidence placed before us have established the following illegalities in the selection process.
Right, 335.
Yeah, just read. I'm
going to place this, my lord. The evidence placed before us has established the following illegalities in the selection process. SSC has appointed an agency, NISA, for the purpose of scanning and evaluating OMR sheets by a closed-door tender process in violation of 14 and 16 of the Constitution of India. Answer is no, because Article 14 and 16, your lordships have said, allows limited tender process. The judgment, my lord, and there are several.
How many bidders were there?
My lord, there were 4 bidders.
So why did you not issue a proper tender? You're dealing with something as sensitive as the appointments to the SSC.
My lord, your lordship may,
To the,
my lord, your lordship may come to that conclusion. I'm not saying. Today we are arguing for notice. It has not been considered. The court says closed door. There is, my lord, a legal concept which is missing in this analysis, and that is of a limited tender. A limited tender, my lord, in...
Let's first read
Yes,
the full paragraph.
right. I'm just answering as I go along, my lord, if your lordships will permit. Otherwise, I'll read first and then...
That's okay.
Yes. Number 2 is, my lord, such agency has engaged another agency, namely data scan to scan. Now, well, this is not illegal, and we are not aware. They are getting their job done. They have not...
Surely the Staff Selection Commission must introduce a condition that you will not hand over this to somebody else.
No, my lord.
Because these are matters of confidence, of trust.
Most certainly it is a matter of...
You have to say that, look, you will do it yourself, otherwise don't bid for the project.
My lord,
The fact that you did not prevent outsourcing shows that you had just turned a blind eye to the whole
I'm not-
sanctity of the process.
my lord, no, this is not a case of somebody coming and saying, I'm introducing a new person. This is, my lord, NICE doing its job, and I am not, my lord, aware that there is another organization which has got involved in it. This didn't come to our attention till the matter was going on. So therefore, my lord, as far as we are concerned, my lord, NICE executives were in our office doing the scanning. My lord,
Now just think, we'll continue 3, 4 and 5. We'll just
now 3. Although scanning was done at the office premises of SSC, it is claimed that SSC has never engaged data scan tech. Naturally, my lord, we are saying that data scanning was done by NICE. Now, NICE says that the actual operative...
But when data scan takes employees enter your office, surely you know that somebody else is entering my office to do the
Not
scan.
disclosed, my lord, not disclosed.
But if your staff is there, your staff is supervisory. For instance, we have scanning agencies in the Supreme Court.
Yes, ma'am.
That scanning agencies, people come here for the purpose of scanning. If they induct somebody else, it's our responsibility to know if there's a third party which is entering into our premises.
Yes.
Because our supervisory control, our officers are doing the supervisory control over who is the authorized agency who is entitled to do the...
My lord, I'm very sorry, my lord.
Some-
No
they-
third party is entering.
Our staff cannot say, well, I don't know who else came in. Because you have,
I know who came in. They came in as NICE employees. There is no indication that the person concerned was somebody else and not NICE. That's not meant to be, my lord, a pun. Now, my lord, so my lord, data scan, my lord, in my respectful submission is a red herring because the work is given to
that's
NICE.
what follows.
Yes, right.
SSC.
Fourth, SSC has destroyed the original OMR sheet ostensibly with scanned mirror image thereof being preserved in its server. Now, my lord, destroyed in accordance with rules, my lord, we say, your lordship may consider that. That's all. CBI did not find any scanned mirror image in the server of SSC. That is true. Because, my lord, we relied on, my lord, the person and the NICE gave us the data at all times. Even today, my lord, NICE is giving the data. Whether, my lord, it is from an ex-employee, whether it is covered by a 65B certificate, all those are questions. But, my lord, the data which the CBI is using, which I am using, all that data has actually come from NICE. Now, my lord, C6, OMR sheets have been destroyed without scan. So, my lord, therefore, there is no...
Now, when you destroyed the OMR sheet,
Yes.
it was the Staff Selection Commission's duty to ensure that the mirror images are preserved in the server.
So, my lord, if
Now, there's no mirror image in the server at all.
So, my lord,
So your case is that, look, I was duty bound to destroy it after a certain stipulated period. But equally, it is your responsibility as the SSC to keep the images, the scanned images in the server.
my lord, fair enough, my lord. The question that you're
Are they not being preserved in the server?
But, my lord, it is being preserved
Where?
in NICE.
No, but CBI doesn't find it in
No.
your server,
No. The digital information is to be preserved.
but in your server.
Now, it has not been found in my server, but it is found, my lord, where it was taken.
But it's worse because NICE at the highest is only outsourcing agency. Imagine your entire data is now found in the server of an outsourcing agency.
So now, my lord, would your lordship...
Can there be a greater breach of security protocols?
My lord, would this be enough, my lord, to set aside, my lord, the employment of 25,000 people is the question. Now, these 3 paragraphs, my lord, are actually one point itself. One point.
Then of the whole process.
So if CBI is proceeding on that basis, CBI is taking that data only to prosecute.
Now, if these were destroyed,
Yes.
look at 7.
Yes.
SSC had provided scanned OMR sheets to RTI applicants in the year 2018 till 2020.
Nice, my lord, from NICE. From NICE.
So that means you knew that the entire data was maintained with NICE.
Of course I did. Not data scan. It was not maintained with scan, it was maintained with NICE.
What was maintained with NICE?
The data, the entire data. Digital OMR data.
But how can that means that you are the statutory body? You allow the entire scanned data to be maintained by an outsourcing agency. It's only a labor provider to do the scanning.
But today, my lord, today that very data is being used in a prosecution. So, my lord, then
Maybe, but today we are looking at your breach of your statutory.
Well, my lord, your lordship will look at my breach.
Yeah.
I am only going to show your lordship, my lord, what is the actual.
You can't say that look nice. Look it away. You are responsible for maintaining it. It is people's data. It is people's data.
Please don't misunderstand. I am not, my lord, blaming nice. I am not blaming nice. I am even accepting, my lord, that without a 65B or not.
Now see what follows.
My lord, just,
I just declare that
if I may just add one thing here, my lord. My lord, if I may just add one thing, my lord. This very data.
They say,
I'm not running away from a single clause. Just let me finish this subsection, my lord.
Yeah.
That the very data that is being used by this court in this judgment and the data which will be used in the prosecution by CBI has completed its investigation. It has said so to the court that we have completed the investigation. Charge sheets have been filed. Now, my lord, that is going on. Now, question is, my lord, this very data is going to be looked at for both the purpose of this judgment and that. So, my lord, the authenticity of this data is not going to be under challenge.
see 7.
Yes, now 7. SSC has provided scanned OMR sheet to RTI applicants claiming that such was from the database, although CBI did not find.
So,
we are saying
RTI queries
yes,
saying this is from my database.
No, I don't know whether it said mine.
Yes.
Just said database.
No, from your database. And now it's come to light that this is not in your database at all. That means what you were saying to RTI applicants that look, this is in my database. So that is incorrect. Look at the Staff Selections Commission's modalities of conducting it, Mr.
Well, it may be, my lord. It may be, but that same very data is being relied upon. Today, this judgment would go if you take away that data. It will have to be set aside. Because, my lord, in one chapter...
There is no data at all.
Suppose there isn't, my lord. Suppose there isn't. Then what will happen to this judgment?
Then the appointments have to go. Because either you have the data.
Yes.
If you don't have any data, we understand that OMR sheets in the physical form, you can't maintain them in eternity.
Yes.
But then two things. You are duty bound to maintain the underlying documents in a digitized form.
Yes.
Because now today with digitization, it obviates the requirement of all that storage and everything. Now you say that look, I don't even have the you provide RTI responses saying this is from my database. Now it's obvious that there is no data in your database.
All right. All I'm saying is, that I am saying
only agency. NICE appoints data of intake.
No,
you are unaware of the fact that your service provider others subcontracted the service to somebody else.
Surely you
had to keep supervisory control.
Very well, my lord. I am not, my lord, on that. I am saying that the very same data which your lordships, my lord, are doubting is the basis for the CBI prosecution and this judgment. So if your lordships, my lord, are not to look into that data, my lord, then this whole judgment has to change. It may still lead to, my lord, investigation, but it cannot be, my lord, what is happening now.
Now, appointments higher than the declared vacancies have been given in respect of all 4 categories.
Appointments higher than the declared vacancy have been given in respect of all 4 categories.
Appointments given to persons who are not even in the panel.
Yes.
Appointments given to persons who submitted blank OMR sheets.
Yes.
Appointments have been given to persons after expiry of the panel.
Yes.
Persons placed lower in rank had been given appointment in reference to persons placed higher in rank in the merit list.
Yes.
Merit list containing marks obtained by respective candidates have never been published.
Yes.
Counselling had been held subsequent to the expiry of the panel.
Yes.
Total beneficiaries of the illegalities are yet to be identified and rendered improbable given the stand of SSC board in the state. SSC had applied for permission to create supernumerary to accommodate the illegal appointees, and recruitment rules governing the 4 categories had never been adhered to either in letter or...
No, that last one is a conclusion.
That's it.
Now, my lord, I have made a chart. We have exact data as to which category which appointment falls into. And my lord, we are not defending. We are not defending appointments which have jumped the list. We are not defending those appointments which have come outside the panel. We are not. We are saying, my lord, that the 16,000 of this 24,000, 19,000 of this 24,000 are not tarnished by any of these clauses. And it is very easy to demonstrate it. It is very easy to demonstrate. We have prepared the chart. The chart will show, my lord, that out of this 24,000, 19,000 were appointed from existing merit lists in accordance with the merit list, within vacancy, within time, everything. And my lord, we were the ones who came forward and gave that data to the court, saying that these are not certain my lord, appointments cannot be justified.
So according to 19,000 are within the merit list.
At least, my lord, that is our rough, my lord, estimate at this point of time. And we told the court that we are prepared to do this exercise all over again. Please see one paragraph only of the judgment, my lord.
But how do you displace these findings, Mr. Gupta?
My lord, I am not displacing all those 4 categories, my lord. I have segregated now.
But look at it's a systemic fraud.
My lord, just look at the directions then, my lord. Is this fair? Look at the directions now.
And ultimately, Mr. Gupta, what happens is this.
Yes.
today public jobs are so scarce
Yes.
and so valued
Yes.
that if the faith of the community in public employment goes,
Yes.
then nothing remains. Because today, public jobs and public employment is extremely valued.
Yes.
It's a source of social mobility for people coming in from the lowest strata.
Yes.
People only aspire that, all right, my daughter and my son will get a government job. If this is the way, we are virtually purloining public employment. What remains in the system?
But Millard, your lordships have said,
How do you displace these findings?
Millard, your lordships have said so in several judgments that if it is possible to segregate, we will not set aside the panel. I'll just show you, Lordship, just two, Millard. One is your own judgment.
Right, where I think Madhu Divana appeared.
Yes. I'll show you, Lordship, one other paragraph, Millard, from another judgment of the same year, 2021, which says that even if...
Interestingly, that was the case where the entire process was set aside.
Yes, correct.
Yes.
But here, your lordships have also had occasion to say that even if there is a small possibility that it is possible to segregate, we will explore that possibility. Because on the one hand, what your lordship is saying is right, that people, Millard, have an expectation of public employment. On the other hand, Millard, these very persons will be on the street.
But you have nothing to show that this is the data which I have maintained.
Millard, I'm sorry, Millard, if this data is...
What you have within your system, any traceable record to show that this is the data I have maintained.
Millard, the prior chairman of this organization is being prosecuted on the basis of that data. Surely, Millard, if your lordships were to cast doubt on that data, then no criminal prosecution can be based on it. Millard, let us, Millard, proceed on the basis. As far as I am concerned, my learned friends may have some other argument, but let us proceed on the basis that the digital data which the CBI has obtained is going to be relied upon. It is another thing that it has come from the custody of the outsourced person. But it is being relied upon by a law court. Millard, just see, Millard, alleged irregularities in percentage, 8.5 for assistant teachers of 9 and 10, 14.7 for 11, 12. The other two are very high. Now, the problem with this order is, Millard, to bunch and put everybody in the same basket. Second proposition, Millard, this is the data taken from, Millard, the CBI record. Now, are we to rely upon it or are we not to rely upon it, Millard? That's the question before your lordship. If we can rely upon it, Millard, segregation is possible. If we are not to rely upon it, then, Millard, there is difficulty.
Yeah.
But then, Millard, the judgment doesn't stand. Some other recourse has to be sought, Millard. Even then, Millard, your lordship will have to go into the question. Of course, Millard, we are submitting that this is an unfair order. Even if, Millard, everything is correct, it is still unfair to say give back the money which you earned by teaching. But C4, persons who have been appointed outside the panel, after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointments, must return remuneration with interest. With interest. So only three categories have to remand it, give it back, refund. So the segregation has to be done. And upon segregation, there will be a large group of people who are not required to give up the fund, the payment. Now they will be faced with a situation that they have lost a job, but they are not held responsible. Millard, on 9th of January 2024, a comprehensive report was given by CBI saying that they have completed investigation. And final charge sheet has been filed. Now, Millard, by what process, Millard, can the writ court say you reopen that investigation now? Millard, that statement by the CBI, Millard, is contained in 9/1/2024, page 743 PDF of, Millard, item 10.1.
Yeah.
Last submission. Yesterday, Millard, have sat and found out various categories. As I told your lordship, Millard, the categories include those who have been recommended as per merit list and some who have been appointed pursuant to orders of court. So these two categories, Millard, should not be, Millard, subjected to, Millard, this cancellation is our submission. Secondly, Millard, as far as extending the period of the merit list, validity of the merit list, Millard, that we wish to defend. Because, Millard, in some cases there are rules, in other cases there are executive orders for stated reasons. We wish to defend that beyond the period.
Yes.
We do not wish to defend and we wish to segregate persons whose OMR data, digital data does not match our...
Yes.
We do not wish to, Millard, defend persons who were appointed from the waiting list, not in accordance with rank. Rank jumping is the phrase, Millard, used here.
Yes.
We do not wish to, Millard, support anybody who is not in the panel and has got appointment.
Yes.
And, Millard, there are some people who have been appointed without our recommendation at all. Those also, Millard, we are not defending.
Yes.
Millard, I'll just give your lordship the judgments. Your lordships are aware. 2021, 4 SCC 631. your Lordship's judgment. 4 SCC, page 631, paragraphs 35 and 55.
Yes.
And 2021 7 SCC, 613, 7 SCC 613, paragraph 73.
Yes.
Which says, my lord, that if it is even possible, then one should prefer to segregate rather than cancel the whole thing. So, my lord, this is my submission.
Yes, Mr. Editor.
Shocking as comes.